In the United States justice system, Supreme Court precedents are pivotal. These precedents are decided by an elite group of 9 justices. Not everyone gets to take their case to the Supreme Court. Those who can't, come to us. These are their questions.
Hello, and welcome to today's episode of Ask the Lawyers. Today we have some interesting questions regarding the First and Fourth Amendments. Before we get started, here's what you need to know.
The First Amendment reads as follows: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. For today's episode, we will be focusing on the Free Exercise Clause of the First Amendment. This means that citizens of the United States can practice any religion they want. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This amendment prohibits unreasonable searches and seizures and requires a warrant or probable cause."
Let's go to our first question. My neighbor is a cop. He was walking past my house and is claiming he saw something suspicious and is now threatening to arrest me without a warrant. Can he do this?
Yes, he can. The Fourth Amendment doesn't apply because the paraphernalia was in plain view. Other exceptions to the Fourth Amendment include consent, stop and frisk, motor vehicle, searches incident to a lawful arrest, border searches, and exigent circumstances, when a warrant is impractical and dangerous. Next question.
A police officer came into my house without a warrant because of an anonymous tip saying that I was running a dog fighting ring. He found evidence against me. Am I going to the doghouse?
You will not be convicted. The precedent of Knapp v. Ohio created the exclusionary rule after a woman was convicted of possessing obscene materials after an illegal search of her house for a fugitive. This means that any evidence found during an illegal search cannot be brought to trial. I used a thermal imaging device to look at my neighbor's house. I suspect that my neighbor is growing marijuana. Can this send him to jail?
No. Kylo v. U.S. set the precedent that thermal imaging is unconstitutional without a warrant. Danny Kylo was indicted on a federal drug charge when his home was scanned by a police officer using thermal imaging, which showed evidence of marijuana growing. Sorry. That concludes our segment on the Fourth Amendment. Let's go to our next caller for a question about the Free Exercise Clause.
Fred told me he needs to kill me next week as a part of his religious duties as a member of a newly created church. Am I safe, or can he kill me?
I suggest you go to the authorities immediately. Reynolds v. U.S. set the precedent that religious duty is not defense for criminal prosecution. This means that no one can get away with killing someone for their religion. Murder is still and always will be illegal. This precedent was established back in 1878 when the Mormon Church tried to argue in defense of polygamy. Anti-bigamy laws will still stand. Next question, please.
We have a caller on line 1.
Hello, my son was fired and denied unemployment benefits after he did LSD for his religion. Can he challenge this and try to get his benefits?
Sorry, but no. Employment Division v. Smith decided that states can deny unemployment benefits to a person for violating a state law, even though it was part of a religious ritual. States can, however, accommodate otherwise legal acts for religious beliefs, but they do not have to. This case involved 2 Native Americans who were fired for taking a hallucinogen as part of their religious ceremonies and denied benefits. Next question.
My city says I can't sacrifice this dog as part of my religious ceremony. Are they infringing on my rights?
Well, according to the precedent of the Supreme Court case, if the city ordinance is directly targeting your religion, it is unconstitutional. However, laws that are neutral and generally applicable are perfectly constitutional. This case was Church of the Lokini Babaluai versus Halia, which involved the Afro-Caribbean-based religion of Santeria and the city of Hialeah in Florida. So if your city has laws against animal sacrificing in general, your rights are not being infringed upon. Please do not kill that dog.